So our next presentation is on community schemes and what the investor should know. Can we learn from multi-family overseas real estate models? Change, change, change. What can we expect from multi-family developments and demographic trends? And to present this presentation will be Marina Constas, and she's a leading and respected sectional title attorney. And I'm going to ask, Marina's coming up. She's also the author of this wonderful book over here. It's called Demystifying Sectional Title. Marina Constas, and I encourage you to read this book. So this book is available, Marina, not so?
Yes.
Wonderful. Please put your hands together for Marina. Thank you.
Thank you. Thank you, Neil. Good morning, ladies and gentlemen. It's wonderful to be here. Thank you so much to the organizers for the very kind invitation. And also, I'd like to say congratulations to all the award winners from last night. This is timeless for me. This conference is timeless because I do think that it's important for our residential property elements to take their place at the table. Residential investment and residential real estate is certainly not the poor cousin of industrial and commercial. And you can just see that there's a vibrant and collaborative community of so many diverse people who are coming, even from social housing, from commercial side, from the industrial side. We all interlink. My world is very much community schemes. I've specialized in community schemes for the last, I'd say, 26 years. I shouldn't give my age away. But ultimately, community schemes made up of sectional title, homeowners associations, that is my world. I've sat on the Community Scheme Ombuds Service Board for 3 years and very much involved in the legislation, in talking to the legal departments at the Community Scheme Ombuds Service. And we will delve into multi-family developments as well, although I must say that it's a word that's really loosely used at the moment. It's not part of our legislation as such. So let's start with a brief overview of sectional title and community schemes. The first thing I need to say is that in 1971, there was a breakthrough in our property law when the Sectional Titles Act came into being, because beforehand you had all these buildings, in Hillbrow, buildings all over Joburg that were owned by quite wealthy landlords who ran those buildings and had tenants in those buildings. There was never a legal concept where you could own a section in a building. And that's where the Sectional Titles Act came, and it caught quite a lot of people by surprise. There were many buildings that didn't know how to deal with this concept of sectional title, but it was one of the most, I would say, prolific changes that caused so many excellent results in our law. But 1971 came, and we had the Sectional Titles Act. And we talk about the historical phases of sectional title as generations. Our act is taken very much from the New South Wales Act in Australia. I've had the privilege of working in Sydney on a roadshow together with a lot of managing agents. And I must say that when you go overseas, you often think that everybody is way further ahead than us. And it was a great surprise to see that South Africa is in fact on the right track and in many, many ways actually way ahead of a country like Australia. And I'll let you know why later. So we talk about these generations of sectional title. The first generation would have been that act promulgated in June 1971, and it became effective in March 1973. Then the second generation came about in 1986, became effective on the 1st of June 1988. And for most of my career, I used that act, because nothing really changed. There were a couple of amendments, but nothing really changed for 28 years after that Sectional Titles Act. And then kaboom, the third generation. So during that period of 28 years, There were numerous consumer complaints levelled at the Department of Land Affairs in connection with sectional title disputes. Where do you go if you have a problem with your neighbour? We can't afford attorneys. Why do we have to go to court every time we need to resolve a problem in all our sectional title schemes? At that stage, a lead consultant was appointed. I remember that myself and Tertius Mare, who unfortunately passed away, he was a colleague who specialized in sectional title in Cape Town. We put together something, to actually get that lead consultant job, but it went to Graham Paddock, and Paddock's put together over a number of years a really concise and comprehensive document on what it would take to build a proper Sectional Titles Act with fewer sections, making it a lot more simple, and also incorporating the exciting community scheme Ombud service. And in that regard, over those years that he was busy with it, different legislations were interrogated. So you had Israel, for example, Singapore, New South Wales, and they actually went to a lot of the different places to have a look at what was going on. So what happened? We had the Sectional Title Schemes Management Act, and that was promulgated in June 2011. It only became effective on the 7th of October 2016. That often happens, that time lapse. And then, of course, the Community Schemes Ombud Service Act, which was promulgated on the 11th of June 2011, also became effective in 2016. And I see that we have our representatives of the Community Scheme Ombud right over there. They're the regulator. At the end of the day, Community Scheme Ombud Service, of all community schemes, which I will tell you the categories as we go. So let's just move on to homeowners associations. So homeowners associations, you'll know as these big cluster developments and estates all over the country, often very large golf estates, and certainly a burgeoning need for people to be living in these type of complexes. Huge demand at the moment for cluster developments because of security and because of the fact that they're actually freehold stands within a walled community. So you've got your common area spaces around the schemes, but at the end of the day, you've got your freehold real property rights within that scheme. But the Community Scheme Ombud Service does govern homeowners associations. Then share block schemes. That falls under the Share Blocks Control Act and the Companies Act 71 of 2008. Share block schemes, also I think around the 70s, 80s, became pretty popular. We were very much involved with Norway in putting together these share block schemes. And ultimately, it's when you have a share, you own a share in a company when you own a unit. Also at the coast, at our offices in Durban, I always used to go down and really get a bit nervous at all these seminars that I spoke at because they all wanted to know about share block schemes. And that's something that everybody just sort of puts aside now because most sectional title buildings, most share block buildings have actually been converted into sectional title buildings. So that's a little bit old school. All right, now community schemes, I think it's important for us to know the lay of the land when it comes to community schemes and what they are defined as legally. Because it's all very well for us to talk about multifamily this and, that kind of loose arrangement. But what is the law in South Africa today? So the definition of community schemes, any scheme or arrangement in terms of which there is shared use of and responsibility for parts of land and buildings, included but not limited to a sectional title development scheme. Right, so these are them, the sectional title development scheme, a share block company, a home or property owners association, howsoever constituted, so that could be with a homeowners association under the Companies Act, or it could just be a loose development of 10 units where you have a constitution stamped by a municipality, for example. A housing scheme for retired persons, and I'm excited to hear about the retirement talk today as well, because that's becoming huge. A housing cooperative as contemplated in the South African Cooperatives Act of 2005. So that is also based on shareholding within a housing development or an institution. So let's start looking at sectional title. I think that's important because a large part of our country is made up of sectional title. Sectional title investment risks. So we're talking now to investors who wanted to buy up a number of units. And for a very long time, there were risks which have been ameliorated. So let's look at the risks. First one, no regulator. Sectional title was a law unto itself. You had to go to an attorney if you had a dispute with anybody. And of course, there we have the Community Schemes Ombud Service, which came into play. So I'll talk about that a little later. Secondly, body corporate financial security. That was a big one because we were dealing with complexes living from hand to mouth. At the end of the day, there was no plan made for the future. There was no talk about how much money was necessary. There were also managing agents sort of often helping themselves to money without proper fidelity fund insurance. A lot of issues around money. So you have a bank account, but that's it. You put your money into your levy fund, and that was it. So with these third generation acts came a separate reserve fund. And that was one of the really good news stories in sectional title. A separate bank account, which every single building has to have now. Separate bank account. And the money that goes into that bank account is set by a formula in terms of the Community Scheme Ombud Service rules and regulations and the Sectional Title Schemes Management Act. So if you have in your reserve fund at the end of the financial year, less than 25% of your expenditure for that past year, then you have to top it up by 15% of the total income for the coming year in order to have enough money in there for maintenance for that year. So that was an important thing, and we still have our bodies corporates coming to the party and trying to get those funds in place. When I was on the board, I know that they were not going to go after every scheme and triple check that the reserve fund was where it should be. They were allowing for people to get together and to raise the money. Money was even raised by special levies. But I know now that slowly but surely, as this community scheme ombud is really getting teeth, and I see that in the proposed amendments that are going to come forward in the next 18 months, inspectors are going to start being sent around to double check on reserve funds, which I think will be a good thing. Lack of body corporate maintenance, that was a risk always, because you can buy the most beautiful developments. We see developments coming up every day, all day, stunning, modern, really, really good. But what happens in 5-10 years after these developments are up? I remember also having the privilege to go to Dubai to see exactly what was going on with those awesome buildings. And I mean, the architecture there is just phenomenal. But you know, in their rules in those schemes, they didn't really have plans, for maintenance and that kind of thing. And I said, well, at some stage, that desert sand is going to get into those buildings in one way or the other. So I'd like to visit Dubai in 10 years' time and see what they're doing about maintenance. But what was the solution here? Those third-generation acts brought in a 10-year written maintenance, repair, and replacement plan. Excellent innovation. And if you don't have that plan now, you will be guilty of an offence in terms of the Community Scheme Ombud Service Act. That plan will talk about lift maintenance. It will talk about exactly what you're doing with your pipes, with the water, with the plumbing systems. And they need to see what is going on in that plan. That plan will then be financed by your reserve fund. So that would be the money going into there. And I think it's important if you're ever investing into a building or if there's ever mention made of maintenance that plan gets taken out sooner rather than later. Dysfunctional trustees. Well, this is one that I encounter every day when owners come and talk to me about sectional title and buildings, and your trustees can literally mean the downfall of a building. And it's not only in I would say the poorer areas. I think in the wealthier areas, trustees have become a real concern, a real problem, because they either want to just run on their own. They become, this kind of, a lot of trustees think that they hold the power in the scheme and they're going to call the shots. And very often they don't have the skills or the knowledge necessary. It's important to note that in terms of Regulation 14 of the Community Scheme Ombuds Service Act, that scheme executives, both in community schemes, like in housing developments, the homeowners associations, as well as sectional title trustees, have the duty and responsibility to equip themselves with as much knowledge as possible in terms of all the acts. And that duty is taken exceptionally seriously. I've had more cases on my desk taking trustees to court for failure to comply with their fiduciary duty than I've had in the past. And that's in their personal capacity. So also, we need to check that the trustees at the helm are equipped for that job in that scheme. There's also a remedy to appoint executive managing agents. I'm not sure if any of you have heard of that. Very nice concept, also from New South Wales. That executive managing agent can be a managing agent, but they actually just come in and act as the trustees. They take liability on, although they will be getting an indemnity in terms of the new laws and regulations coming in. But at the end of the day, that is something really great for sectional title. So you can even have trustees who are not in your building, business people who come in, and then you can have an executive managing agent and a well-run and better building. So it's great to note that that word executive managing agent is coming to the fore in all the amendments that will be coming in, I'd say, probably, again, as I say, about 18 months. We've been working quite hard with the legal department at the Community Scheme Ombuds Service to work through the bills and the changes that are being made. And one thing I do want to mention, which is of really great importance to any banking people here today. Community schemes must be registered. They've got to be registered with the Community Scheme Ombuds Service. So going forward, if a scheme is not registered when these new changes come in, not as the position reflects now, but soon enough, you're not going to be able to get a bond in a scheme that's not registered, and you're not going to be able to get a loan. The body corporate will not be able to get a loan from any banking institution if that body corporate is not registered. Application for administration, also something you can do in a scheme if that sectional title scheme is going completely downhill. And administration, again, is not only for buildings where there are no trustees or there's nobody interested or there's a financial difficulty in the building, because that's where administration comes in. You can now go to the magistrates' court and place a building under administration. It used to be the High Court. So, for example, a building like in Cape Town, near Greenpoint, the Cape Royale, I don't know if any of you have heard of that. That building went under administration because the trustees just couldn't really get it together in terms of managing the building, so it was taken to court. Debilitating arrear levies. This is the biggest risk facing all community schemes. All community schemes. Arrears has probably, I would say, in my narrow vacuum of experience in our firm, and we've got 5 branches across the provinces, we deal with arrear levies, probably quadrupled the number of arrear levies that are coming in every day. And that is going to cause really great harm to our complexes. So you have to treat the building as a business. You've got to strike while the iron's hot. You can't let people get into arrears. I mean, I've got a matter now where we did an application for disconnection of electricity, which you can get by way of a court order only. The body corporate can't disconnect. So don't go to your buildings and start disconnecting electricity. Only by court order, high court order. I mean, we've got 3 matters on the go at the moment. The one chap owes 600,000 rand in arrear levies, the other one 400,000, and the other one 210,000 rand. in their levy payments. So those buildings really need to be taken to task, because you can't just let levies climb like that. That's awful. So we need streamlined collection processes in buildings if you're investing, proactive trustees, and of course my biggest bugbear is better support from our courts. And that is something huge. Any attorney here will know. You go to the courts, you try to get default judgments, warrants of execution issued. It's a quite a long and sad process at the moment. Right, so let's just go on to Community Schemes Ombud Service, the Act and the regulations. So the Community Schemes mandate and aim is basically to house corporate governance documentation. That is, all your rules, all those rules are now at CSOS, and you need a compliance certificate for the rules in your scheme. So if you're amending any rule in your scheme, like for example, the biggest amendment at the moment that we're making at BBM Attorneys is solar. All the schemes at the moment want solar panels. So how do you go about putting solar panels up? What resolutions do you need? Who's responsible for maintenance? What happens if you want to take those solar panels down? If the inside, if those batteries and things are in the inside, who's responsible for the maintenance of those? So all those rules are housed at the Community Scheme Ombud Service, no longer at the Deeds Office. They're also attending to dispute resolution, providing mediation and adjudication platforms. And to go now to the Community Scheme Ombud Service, which is based in Centurion in Johannesburg, the cost is nil. They've waived the fee. It used to be 50 Rand for a mediation and 100 Rand for an adjudication. At the moment, there's no cost to go to CSOS to take your case. Tenants can go to CSOS, and owners can go to CSOS to take the body corporate to CSOS, or vice versa. And the last thing is to provide nationwide educational programs and campaigns and about community scheme ombud functions, which I think is really working quite well. So, yeah. Again, what is a community scheme? Let's go over it. Sectional title scheme, a homeowners association, share block building, retirement village, gated community village with a constitution, and housing cooperative. The functions of the service: to develop and provide a dispute resolution service, to train conciliators, adjudicators, and other employees of the service, to regulate, monitor, and control the quality of scheme governance documentation, and to take custody of, preserve, and provide access or electronically by any other means to scheme governance documentation. So they have a huge, huge mandate, and I'm very happy to see that the CSOS is growing. I think that things are going to get better. I've always give the CSOS another 5 years to really put into place structures that are going to be valuable. So in performing its functions, the service must promote good governance of community schemes, may provide education, documentation, and awareness, must monitor community scheme governance, and may generally deal with any such matters as may be necessary to give effect to the objectives of this Act. So in other words, the Ombud has got a responsibility here to use his or her discretion to deal with any matters around community schemes. Right, before we talk about multifamily developments, there's also something else which I think is important. It came out of something that popped onto Facebook for me. It was by a friend of mine. His name is Kura Chihota, and he spoke to me about Zimbabwe. He's in Zimbabwe in the property game, and he said to me, Marina, you would really have a heart attack if you saw how these developments are built. Just sections all over the place, just things being popped onto other things, all disjointed buildings. And there, again, we've got a responsibility here to appoint land surveyors to survey these buildings. And I think the Act is going to be exceptionally useful in terms of things like that going forward. All right, let's just touch on multifamily developments. I'm going to talk about it more when we sit on the panel later. But a multifamily development is exceptionally popular overseas concept. It's not South African, especially in the States. 2 or more households renting under one roof, tenants sharing walls, floors, and utilities. Laws and regulations for multifamily housing vary from state to state in America. Started in the 1800s in New York with a 6-story building and 15 units. Portland residential real estate market is in the States. always been huge growth due to crisis in housing, which we currently have, and it talks to apartments, condominiums, and townhouses. So if you look at that, both those examples would be multi-family developments overseas, high-rise as well as smaller buildings. Perhaps a new scenario for South Africa. Let's have a look at it. We need a high-density support system, neighborhood revitalization, bringing professionals into big cities. You get more rentals as an investor because you've got more units to get money from. And there's a shift from ownership to rentals. Rentals are much more popular with the youth today than ownership is. Things are shifting, changing in a big way. Changing properties from single homes to multifamily instead of building new apartments, best harnessing spatial frameworks that we can all agree on. But of course, then we need to look at and interrogate consent, use, rezoning, and township developments to amend what has happened already with sectional title and housing, to amend that to reflect a multi-housing reality. And we're going to need legislation, a huge amount of money. Rental, what are the advantages? The last slide, to generate higher rental income per investment opportunity. Lenders view them as low risk because you don't need to have 100%, because they don't face 100% vacancy. Investors benefit from natural appreciation between 8 to 12% on the American models. Higher rental income allows investors to hire property managers, but the one problem probably is it might be difficult to sell a multifamily property because it depends on location, totally. So we need to look at that. But the last thing that I can say, it's all about infrastructure, infrastructure, infrastructure. If there's no infrastructure, you can forget all of this. You can forget urban densification because we may then be in a position to face the slums of the future. So on a positive note, I really think that we all need to learn from this, and we have a responsibility as property people to make sure that things go in the right direction. And thank you so much. Thank you, Neil. Appreciate it.